I know your lordship's view, but this is the only court which is available irrespective of classification. My two matters were supposed to come in Justice Parthasarathi Chatterjee's list on Monday. Unfortunately, now since the determination has changed, we will have
His
nowhere else.
lordship still has determination.
No,
Though
lordship,
he's
not
sitting in
group
division.
two matters, not group two matters anymore. Lordship, this is persons are without pension. Lordship, please kindly
No,
take it.
How I'll be able to take it, because with so many motions
Lordship
already
has
there,
come from the bench. Lordship knows
That I
our
know, but
predicament.
Still, I cannot ignore the motions which have already been
That's
there.
true. I completely accept. If your lordship gives at least one day for
I'll
hearing.
try. I have just begun. It's only one day that I have devoted to this.
Lordship, may I leave my slips behind in the event?
Won't serve any purpose, ma'am. Maybe next week you try. Let me see how I proceed this week.
Lordship.
My lord, may I kindly mention, my lord? I am mentioning, my lord, for listing before your lordship. All these matter are new motion, my lord. Running in the list of before the Honorable Justice Rajabashu Chaudhary, monthly list, my lord. Around 30 matters. So shall I, my lord, hand over the serial number in?
You can give the slips. You can give the slips. They are not in the list.
No, my lord. And the monthly list, my lord. Not all new motion, my lord.
All the matters which were some of the matters coming.
New motion, all the new motion.
Very well. You give, those will appear. দিদি যেগুলো নিউ মোশনে আসার কথা আসেনি, মান্থলি লিস্ট, সেগুলো
My lord. All the matters, my lord, in a single list.
Motion give. Yes, give.
May I give your lordship, please, my lord, intimate others also, my lord, so that all those
Yes,
matters,
yes.
my lord, that will
Motions you can give.
My
Give
lord.
the slips. They will.
Certain matters which appeared in the monthly report of December 2025. They were appearing in the monthly.
Motions.
Yes, your lordship.
Yes, motions.
Your lordship.
Called
May I be
Well,
permitted
motions,
to
my lord.
mention
দেখুন অনেকগুলো মোশন বাকি রয়ে গেছে বলছেন ওনারা।
Well, motion, my lord.
মোশন গুলো তো দিতেই হবে। হ্যাঁ, slowly they will come. All of them won't be listed on the
But
same
definitely,
day.
my lord. My lord, we know that there is a huge pendency.
Because I'll be showing 3,000 matters in the list and taking 10. That doesn't make sense.
My lord, my lord.
So they'll be included in the list slowly as I proceed.
those matters are from filed in the month of April.
2024, my lord.
some of the from the year, some of it.
April 25.
Well, the predicament is the department now they have formed a cell whereof they are threatening the dealers that if you don't have any stay or it has not been disposed of, the recovery proceeding will be starting, my lord.
Some of that started.
Well, already some of them have started, my lord. Well, I'll hand over, my lord, slip.
বলছি তাহলে আমাদের পিরিয়ড ওয়াইজ একটা তাহলে স্লট করে নিতে হবে। এপ্রিলে পেন্ডিং আছে, এপ্রিলে ফাইল করেছে, সেপ্টেম্বরে ফাইল করেছে, মে মাসে ফাইল করেছে, অক্টোবরে ফাইল করেছে, সেই অনুযায়ী তাহলে লিস্ট
tried to log in through virtually, matlab he couldn't.
लेकिन none appears for the respondents, full stop. उनका नाम लिखे लेना. Appears and submits that Mr. Piyal Gupta, learned advocate appearing for the petitioner, is out of station for compelling reasons, full stop.
My lord, yesterday, my lord, had directed me to take instruction in this matter because engagements have not been done in this matter, my lord. I spoke to the department. They have said that maybe a copy they will need, and my lord kindly keeps it after 12th.
My lords, we have served, but it's
All right, let लिखे दे. Mr. Anurag Rai, learned advocate, appearing for the. You are appearing for all the respondents.
Yes, my lord, customs.
Appearing for the respondents, submits that a copy of the writ petition may be served upon him, full stop. Learned advocate appearing for the petitioner, however, submits that copy of the writ petition has already been served upon the respondents, full stop. Later copy, comma, as prayed for by, as requested by Mr. Rai, prayed for Nagpur, as requested by Mr. Rai, comma, let a copy of the writ petition be served upon him, full stop. List this matter once again on November 12th,
my lords, any date after 12th, my lords.
after 12th. ठीक है, लिखे दिन. As prayed for by the learned advocate for the petitioner, list this writ petition on November 17th.
Very well. Grateful.
Respondents have not received copy.
My lord, they they are not certain about this thing. There's been some organizational shake-up, my lord, so a little bit difficulties being faced.
Very
Grateful, my lords.
yes.
My lord, senior is not well, your lordship. Praying for not this week, your lordship. He has a frozen shoulder issue, your lordship.
An adjournment is
3
prayed
and
for.
4 both similar matter.
An adjournment is prayed for on behalf of. No, adjournment is prayed for citing the illness of the learned advocate appearing for the petitioner. उनका नाम लिखे नेबेन. Miss such and such appears, वही भावे लिखे, and prays for an. Yes.
Yes, my lords, we are actually challenging the appeal order, which has been actually rejected because of delay. But there is an inherent issue with the show cause notice and also the rejection order. And my lords, this is also a covered matter by the Honorable Division Bench also.
Your Lordship, the panel councils are not here yet, so if an adjournment can be, short pass over can be.
What is, let me see the order.
Yes, my lords. If my lords would, my lords, actually, I had a registered office and I got it amended in April 2022. The amendment was duly approved by the department, CGST department. After the approval on April 2022, suddenly I get a show cause notice, which is the show cause notice is given on page 33, my lords.
Page 33.
Yes.
Yes.
My lord, the show cause notice just says that on the basis of information which come to my notice, registration has been obtained by means of fraud, willful misstatement, or suppression of facts. So no details have been given as to what is the actual allegation, why it is suppression of fact, why it is treated to be fraud. And if my lords would now go to page 34, which is the order for rejection. Here he comes up, the learned proper officer comes up with a reason, which is a borrowed satisfaction, which was never made available to me at the show cause notice stage.
How did you respond to this show cause notice?
My lords, we did not respond to the show cause notice because we did not receive it and
You
very.
have asked for reasons then.
My lord,
On this ground, show cause, why is the appellate order wrong?
appellate order is rejected on the basis of limitation, my lord.
You go before the appellate authority. I'll ask them to condone the delay or to deal with your application.
Okay. Oblige, my lord.
I'm passing it over. Let the other side come.
Okay. Oblige, my lord.
Pass over kore rakhun didi. Only if they come, I'll pass the order, not in their absence.
My lord, may I argue at that point of time? I have one more argument in this.
Very well, let them come then.
And in item number 6, my lord, I'm for the petitioner, my lord. I'm led by Mr. Bach, my lord. He is coming in 2 minutes, my lord. In the meantime, my lord, I may. Thanks to your lordship. Lord, this is an writ petition, my lord, whereby my statutory appeal, my lord, it was rejected only on the ground of a delay of 59 days, my lord. So the merits was not adverted to. It was only entered rejected on the grounds of delay. Lord, may turn to page 61, my lord. That is the impugned order, the order of the appellate authority. Lord,
61.
61, my lord. That is the order of the appellate authority.
Yes.
Lord, so, Lord, if my lord peruses the order, Lord, my lord will see that the instant petition was filed against the demand order such and such, my lord. And it says that a hearing was fixed on the date for fixing 17/7/2025 at 11:45 a.m. my lord, on page 62, my lord.
What is your reason for delay?
Lord, I have, my lord, indicated the reasons for the delay, my lord, in the my appeal itself, my lord. If my lord kindly comes to page 58, my lord. Page 58 to 60, my lord, I have indicated the reasons for delay in details, my lord. My lord, the difficulty was that, my lord, the DRC, the notice in DRC 01A, my lord, the notice in DRC 01, my lord, nothing was personally served upon me, my lord. Everything was. My lord, I am led by Mr. Bhagat.
I apologize, my lord. Lord, very brief point, my lord, here. I'm praying for, my lord, condonation of delay for a period of 59 days. Lord, I'll indicate, my lord, where we have explained, my lord, the delay. First, may I show, my lord, what is my prayer here?
Lordship will kindly take up. It starts from page 13. Let's cross check. And I'll quickly take your Lordship, my Lord, to the main document, which is my explanation of the delay. I was out of time in filing this. Why out of time? We have explained, my Lord. Only this much. May I quickly show?
Yes, Mr. Sanyal.
And there are 3 judgments of our court, which I'll place in matters where there were, my Lord, 600 days delay, where the Honorable Court was pleased to condone the delay for ends of justice. We have good case on merits. All that I'm praying is, my Lord, we be given a chance to, my Lord, place our case on merits. Today, if, my Lord, I'm shut down, then that chance will be, my Lord, gone forever. That's my case. I'll quickly indicate, my Lord, the judgment so that give me the judgments. As we decided to be the first one. I'll not trouble your Lordship with too many, but first, my Lord, Arvind Gupta, in all these decisions, my Lord, the point was Section 5 application in a 107 appeal. That's, my Lord. Let me start with Ashok Kumar Jaiswal, paragraph 4 of this judgment. Give a copy to the other side. Paragraph 4 of the judgment, my Lord. That explains the entire thing. My Lord, Mekel construction is the most recent. It's very recent, my Lord, December 24th. It explains the judgment in S.K. Chakraborty and also, my Lord, lays down why the condonation should be, my Lord, permitted. Give me one more copy. If my learned friend, my Lord, perhaps would take a point, so I should indicate it beforehand. S.K. Chakraborty is a judgment which was stayed by Supreme Court, not overruled. So he may indicate that this is state, but I should be candid, my Lord. I'll indicate this was state.
I am in support of my learned friend.
There is-
If my lordship goes through the appellate authority order, I will not stand in the way. Not much is said. Should have
Very well,
stayed-
my Lord, then I'll not make any submissions. If that is, my Lord, being conceded to,
because
then, my Lord, there's no
I
requirement for
carry
me to.
upon the facts, your lordship.
Within.
May I have, my Lord's kind
Yes,
leave, my Lord. I'm
please.
very deeply obliged.
This writ petition takes
And my lord, I am appearing for that. My lord, this is a matter, my lord, wherein I am challenging the order of the GST, my lord, along with the attachment notice issued by the state GST authorities, which has both has been in entire proceeding has been initiated after the date of the taxable person, my lord, which is solely restricted under the provision of the law, my lord.
If the taxable person, your lordship kindly refers to section 93.
Yes, my lord. My lord, prior to that, my lord, may I be one point is required to me, my lord. The legal heirs, has duly intimated the authorities that they are not continuing with the business, and they have filed a cancellation for GST registration, which was rejected by the authorities also.
But they are not challenging the cancellation. They are only
My lord, subsequently it was cancelled to a suo motu, my lord, and then
was there subsequently as per my instruction. But if the business, your lordship, as per section 93, if the business is carried on by the person is discontinued, whether or before or after his death, his legal representative shall be liable to pay out of the estate of the deceased.
my lord, the proceeding has been initiated after the death of the person, my lord. That is the case here in my lord.
Section 93.
Yes, my lord.
Yes.
93B. If the business carried out by the person is discontinued, whether or before or after his death, his legal representatives shall be liable to pay out of the estate of the deceased to the extent to which the estate is capable of meeting of the charge.
Yes, madam.
Yes, my lord, the law says that, my lord, and it has already been well settled by this our jurisdictional high court also and other high courts, my lord. The proceeding has to be initiated in the in the name of the legal heir, my lord. Until and unless that has been, my lord, the legal heir has never been given any opportunity to respond, my lord. The issue is that the entire proceeding has been initiated after the death of the person and getting the information about the discontinuation of the business also, my lord. The legal heirs has duly intimated before initiation of the proceeding, my lord. My lord, may I refer the annexures, my lord, now?
Yes.
Yes, my lord. My lord, kindly come to page 32, my lord. That's the date certificate of the taxable person, my lord. He was died on 2021, my lord.
Yes. How did you inform? When did you inform?
My lord, we have informed the authorities, my lord, in prior hand, my lord. Page 55, my lord. Page 55. Yes, my lord. This is the application for the cancellation, my lord. I am unable to trace, download the entire application, my lord. This is the application, my lord. Now, this was the application, my lord, wherein it was filed by the legal heir, my lord, and for cancellation, my lord, and that was rejected by the authorities, my lord, and rejected, and the show cause notice for rejection was issued on immediate next page, my lord, 56.
The application for cancellation was
Yes, my lord.
filed on 22nd of August 2022.
2022, my lord, and the show cause notice has been issued for the proceeding, my lord, that has been issued after this intimation, my lord. Page 58, my lord. 25th August 2022, my lord.
If the application for cancellation of registration has been rejected, then in that case the name remains, isn't it?
My lord, the application without considering the fact, my lord, before rejection of that order, my lord, application, my lord, they have initiated. My lord, what is my humble submission before your lordship is, my lord?
No, it doesn't appear so. Your application for cancellation of registration is dated 22nd of August 2022.
22, my lord.
The rejection comes on the same day. That is
no, my lord, that's the show cause notice, my lord. That's the show cause notice, my lord. Notice for seeking additional information, clarification, documents relating.
Because
Yes,
you did not respond to that.
My lord, I have, my lord. The next page is, my lord, the order of
No, page
rejection.
57 says that you
Yes,
did not
but
respond.
my lord, first paragraph, my lord, this has been reference to your reply filed by ARN such and such, dated such and such. My lord, I have filed the reply. My lord, today I am unable to download the reply. My
No,
lord, the portal does.
that means that the application which you are showing at page 55 is not the actual application, it is the reply.
My lord, this
to
is the
show cause.
acknowledgement of the application, my lord. This is the acknowledgement of the application, my lord. My lord, today, my lord, then my lord,
Where
I
is
have
the
to.
reply then?
My lord, that
Because
reply.
they say yes, Mr. Chakraborty, at page 57, it says that reply has been examined, same has not been found to be satisfactory. And then in the next line it says no response received as per SCN issue.
I have seen, but I have to take instruction.
Because this doesn't make sense. If no reply is given, then no question of examining. Then the first line.
No reply.
And my lord, the issue is that, my lord, if I have applied only for the reason for the death, my lord, then the question of non-satisfactory reply, my lord, that is also a question, my lord, because that is the issue, my lord. The taxable person has expired, my lord, much prior issuance of the notice.
Very well, लिखें in order. Learned advocate appearing for I
was stuck in a
no, not at all. This writ application seeks issuance of a writ of mandamus. A writ of issuance of writ purota ketedi. Likhun, this writ petition assails an order dated January 18, 2023 and a recovery notice. But why have you come after 2 years of the order of you didn't know about? Very well. You have this explanation in the writ petition. Very well. 18/2023 and the recovery notice in form FORM পুরো সব ক্যাপিটাল এগুলো যেটা বলছি ফর্ম GST তারপরে DRC তারপরে স্পেস দিয়ে 13 dated May 8, 2025 on the ground that the proceeding has been initiated against a dead person and in the name of a dead person. Full stop. Paragraph. Mr. Chakraborty, learned advocate, appearing for the respondent. Respondent numbers, because Union of India is also a party. Respondent numbers 2 to 4. Respondent numbers 2 to 4 seeks accommodation to take instructions. Full stop. How many days? List this matter for further consideration on November 12th. 12th November? 12th November. Affidavit of service to operate. Yes, madam.
Yeah, what type days? Well, who is before your lordship? Is the contractor, government contractor, and what is the ground for his appeal is that the petitioner has neither knowledge of GST nor understanding the GST matter, madam. This was the ground
There is a
before
ground
the
of
appellate
illness of
authority.
his wife also.
Yes, my lord. That apart, my lord, this applicability of section 5 in a
That
GST
has been
case,
decided
my lord,
at least
there
by
are
this court.
very yes, my lord.
Division bench of this court is there. So
And that order
hear it on merit.
my lord, that SK Chakraborty, my lord, has already been, my lord. There is a stay by the Honorable Supreme Court.
Yes, but stay will not
My lord, whether this
stay will not rob it
section
of its
29
presidential flavor. Stay will be operating
my
inter
lord,
parties.
yes, the matter is pending. Yes, it's not minding, my lord, to the
Hear
other.
it out on merits. 159 days delay here. The petitioner is aggrieved by an order dated. Give me the dates of the orders by an order dated. June 25, 2025,
My lord.
passed by the appellate authority under section 107 of the GST Act, 2017. Full stop. Paragraph. It is the petitioner's case that the petitioner approached the appellate authority by filing an appeal under section 107 of the said Act, laying challenge to an order dated. What is the date of the adjudication order? Order dated April 29, 2024, passed under section 73 of the said Act of 2017. Full stop. The appeal against the adjudication order was filed on
12th February 2025.
on February 12, 2025. That is after, that is with a delay of how many days?
196.
Of 196. 196 or 106? Delay
196, my
of
lord.
196 days. Full stop. The appellate authority has dismissed the petitioner's appeal being dissatisfied with the explanation for delay. Full stop. Having perused the application for condonation of delay and having regard to the fact that where is your application for delay? Page? That the delay has been sought to be explained on the ground that the taxation related work of the petitioner's firm was looked after by the petitioner's accountant, and that the petitioner's wife was suffering from heart ailments, The delay of 196 days occasioned by the petitioner seems to have been plausibly explained. Full stop. Paragraph. In such view of the matter, the explanation given by the petitioner is accepted and the delay occasioned in preparing the appeal is condoned. Full stop. The matter is remanded to the file of the appellate authority, who shall hear the appeal on merits in accordance with law. Full stop. WPA 20168 of 2025 stands disposed of without any audience requests. আচ্ছা, একটা জিনিস লিখে নিই। The petitioner relies on a judgment of a coordinate bench of this court in the case of Vishwajit Das versus the state of West Bengal and others, within brackets WPA 693 of 2025, to assert that Section 5 of the Limitation Act, 1963 is very well applicable, and the authority could have condoned the delay if sufficient causes are shown. Affidavit of service to observer.
Not there. In person, he has verbally said that can be asserted from the order itself. The IPC should also page 40. You could not give sufficient reply. You could not. Now the person even also. You are even to re-answer some other things. 108 days, we can put out.
You go and file an application for condonation of delay there, he'll consider it. লিখে নিন। This writ petition assails an order dated December 3, 2024, passed by the appellate authority under section 107 within bracket 1 of the SGST/CGST Act, 2017, whereby the petitioner's appeal against an adjudication order dated April 18, 2024 was dismissed. Full stop. Paragraph. Upon perusal of the order impugned, it appears that the appellate authority has dismissed the petitioner's appeal on the ground that the appeal was delayed by 7 months from the by 7 months. Now that the appeal was delayed, having been filed beyond 7 months from the date of communication of the order of the adjudication order. Full stop. Paragraph. Adjudication order. Full stop. Paragraph. It is submitted by the learned advocate appearing for the petitioner that although you did not make any application for condonation of delay, or you had?
Advocate was given. I can find a place application. application as per your direction. Yes. Here appeared before person.
কি লিখলেন? Although it is not clear as to whether না এটা কেটে দিন এইভাবে লিখুন the order impugned does not reveal that any application for condonation of delay was filed. However, it reveals that the authorized representative of the petitioner who appeared before the appellate authority failed to provide any satisfactory reply as regards the delay occasioned in preferring the appeal. Full stop. Paragraph. Having regard to the peculiar facts and circumstances. Now, full stop. Ebar paragraph learned advocate appearing for the petitioner submits that have you made any averment that he suffers from neurological diseases? Where? Learned advocate appearing for the petitioner draws the attention of this court to paragraph 8 of the but this is the illness of the advocate.
Advocate, you know, he was conducting the matter.
Paragraph 8 of the writ petition and submits that the learned advocate who was dealing with the petitioner's case before the appellate authority had been suffering from neurological problem, and as such there was delay in preferring the appeal. Full stop. Paragraph. Be that as it may, comma, since it does not আচ্ছা ওই WPA ওটা ডিসপোজড অফ পরে লিখে দেবেন WPA নাম্বার দিয়ে ডিসপোজড অফ হ্যাঁ
There is nothing to say that bring back to the case of purchase of land. And they have issued so much notice on the ground that their suppliers registration has been cancelled. That's the usual. Now, from the order defined, first time we found that it has been alleged that there is non-existent. But application of Shlokas has been filed issued under Section 70, which primarily shows that there was no verification on my part. Secondly, Your Lordship, all the documents, I'm not adding to documents at the time of hearing Your Lordship, the entire documents. However, the first point, you cannot go beyond the Shlokas. 20. So page 20, your worksheet. Page
Very well, then they'll have to file their affidavits. That is to be decided on affidavits.
No, that I have not checked. Ultimately.
You're not challenging that.
That I have not. Even if I have not given a prayer,
No, there is no prayer.
there is no prayer. If I like anything, without a prayer, how does it matter? There is no prayer.
लिखे नहीं. The tribunal is not functional as yet.
No.
On this writ petition.
Page 46. I think him submit was a mistake on my part. On the part of the advocate. That has been on screen. Told in this government also. Paragraph 7. And paragraph 20 or
Where is your explanation for delay before the appellate authority?
page 46 your lordship. Isn't what we
No, page 46 is not the explanation. It is the that shows the principle of law. Where is the explanation? Why? Why it was?
that is written. The fact reasons stated suggest that the delay
Where are the reasons? Reasons are stated above. That means in page 45. Page 45, 45. Reasons are at page 45. It was posted on view additional notices tab. That is the. There is a judgment of our court also. No, single bench.
division bench has replicated this. Page paragraph 51 and paragraph 51 and 52. This has been arranged. This has been this cannot go on. Paragraph 51. Mine is better. Here, at least DRC 01A was uploaded in the main tab. Nothing was uploaded.
So this is a good ground to condone the delay. Mr. Chakravarti.
This I have checked it up whether it is correction or not. Matters. But I would find all the check with the evidence. This is also your point.
But division bench. No, I found a single bench of this court also. No, Justice Bhardwaj. Saint Xavier's something. But then if the authority does not come up with the evidence, then in that case this. This writ Rectification application passed in appeal. Acha, no tribunal available.
Which gave liberty that if ITC of 1780, 1890, 1920 is availed up to 30th November 2021, it is valid input tax. 16th code provided that I can avail for financial year up to September of the next financial year, return of September of the next financial year. That was the normal provision for these 3 years. 1780, 1890, 2020. Then because the government noticed that many SSC have filed their returns belatedly for the previous years, so the government brought in an amnesty scheme in form of section 16(5). 16(5) provided that if any input tax credit of any invoice for the period 1780 up to 2021 is availed if any GST credit filed up to 30th November 21, input tax credit is allowed. You cannot deny me the credit on the ground that I have taken it belatedly. That was the provision inserted, especially from 22nd September 2024 with retrospective effect from 1st July 2007. My case is for 2021, wherein in March 21 we return, I availed certain credits of 1819 and 1920 on the ground that I had reversed these credits earlier on account of non-payment to suppliers. But the department issued me a show cause notice alleging that there is a difference in my GSTR 3B and GSTR 2A credit. I explained to the department in my reply that this difference is on account of my previous period credits, which I have availed in subsequent year once I have made the payment to my suppliers. Department, a single line order stated your reply is not acceptable and confirmed the demand. I went before the appellate authority. Appellate authority also, in the same lines, confirmed the demand without giving me any benefit. Now, in the meantime, Lordship, the government comes up with this amnesty provision. And the government provided that within 6 months of 7th of October 2024, you need to apply for a rectification application. If it is in appeal state before the appellate authority, if it is in the adjudication state before the adjudicating authority.
For availing the amnesty.
For availing the amnesty and the special amnesty at 140. I filed my rectification application before the appellate authority because in my case, appellate order had been passed. The appellate authority in the meantime changed. The person who had passed the appellate order and the person for whom the amnesty application, the rectification application came was a different person. It can happen. But the particular officer rejected my rectification application on the single ground that the issue in your case was not of section 16(4). It was only of 2 and 3 different, therefore this benefit I will not have. And in the meantime, the department has recovered 17 lakhs from my credit ledger. I have all throughout participated, submitted replies that these are, and I have attached my annual returns also with my show cause reply, wherein I have shown for 1819 this credit I will avail it next year. In 1920 annual return, I have shown that this much credit I will avail in subsequently. And 2021, I have availed all these credits. And the government changed the law that okay, if you avail any credit within 2021 of previous period, your credit will be allowed. So, 2A is an auto-populated statement. In 1819 and 1920, my ITC is flowing into it. There is no indication. But when I am availing it in 2021, in 2021, 2A, the figures of 1819.
So what has the authority done here?
Take the show cause.
Page?
The show cause starts at page 59. 59 is the summary. But the show cause starts at 64.
Yes.
There was a pre-show cause also, Lordship, through which we had also referred. In 64, Lordship, there's difference in 3B and 2A. The heading, the subject is there, Lordship. Case 64, intimation of liability after receiving reply from the registered payer in connection with notice reference dated this. I have gone through the reply. In the reply, RP expressed that he has availed excess amount of ITC of 2021 or amount to this, which he reversed in 1819 and 1920. He has no quoted this. that it is for 18, 19 and 1920. After examining from the submitted 3B of 18, 19, 1920, it is evident that the RP invoice an amount of this. Hence, the amount of tax interest payable under 73 with reference to the said case is ascertained. Ground of quantification. This is important. Upon verification of 3B and 2A for 2021, it is found that IPC it is more than 2. Mr. Lordship, when I have already told that this is for 18, 19, 1920, so in 2021, 2A will not have the flow. Any invoice of say 1st April 2018, my supplier has issued, he has filed return of April 2018 in GSTR 1. In my GSTR 2 of April 18, that invoice is coming. Now, as per the provisions, I have to pay to the vendor within 180 days of invoice. Then I am eligible to ITC. Now, because I was a new unit, I could not make all the payments in the same year. So I reversed the credits. I availed and reversed the credits, I netted it off. 100 rupees was eligible, 100 rupees I reversed. So in 3 I did not avail any credit. Now, in my annual return, there is a table 8C, which calls for all the information which this year ITC I will avail next year. I disclose that figure in that particular table. Now, when in 2021 March,
When you reverse it, is it not shown anywhere in the auto population?
in auto population it is not. In 3B Lordship, there are two options to reverse. Either I show it in the reversal order or I net it off. And there was both circular because it was a new design, everybody was netting it off. As per 2A, because in 2A also Lordship, if there is any credit note coming.
So when you net off, how would the department know about it? That you have.
When the department issues a notice, we give them the calculation. See, this is my record. Actually, the Ashton design, segment credit, excise design, there was admitted register RG 23A, 23C, which had invoice level details. But information which was given in the returns, monthly return was only the summary. Now we used to submit hard copies of that register also in the return in the excise region. But in GST,
So in reply to the intimation notice or whatever pre-show cause notice, you intimated them that this is how you have netted it.
Subsequently, when there was now the
Which is why the first paragraph saying that
yes,
you have reversed it.
appeal authority till the time appellate authority decided this 65 was not introduced. I will defend it to the record, but when subsequently it was introduced, then I was again entitled to benefit of that. Even I was covered by Rule 37, but for that matter, if I say Rule 37 is not applicable, Rule 37 I say Lordship, that if I have reversed any credit of previous year, I can avail it subsequently without the time bar of 16 4. This is a specific rule. But even if I say that is not applicable for the time being, then through section 16(5), any
And your reversal were within time bar because
within time,
all within 180 days.
when I apply for rectification under the special procedure notified to the Lordship by 48, the appellate authority rejects my rectification stating that the issue in your show cause was 2A 3B, not 16(4). So therefore, I will not give you this benefit. So now I am in the meantime they recover 17 lakhs from my credit line. So I am left with nowhere.
Yes, Mr. Chakravarti. Yes, because see, if he has netted it off, he has reversed it. Then in that case, he is entitled to it. And when the statute itself or the legislature has recognized this kind of a situation and has embedded it, incorporated in the statute, thereby granting it right to somebody, why should that right not be available to him?
In that time, no course of action was already 17 lakhs recovered subsequently.
Please don't do it. Please don't do it.
17 lakhs recovered. I have reported it. I reported it.
He's there, he's assuring he will not do it. Gentleman's word, we should.
That assurance will make it.
This writ petition takes exception to an order dated. Where is the order?
The rejection order is at
Yes.
24.
To an order dated June 30, 2025, passed by the appellate authority, thereby rejecting the petitioner's request for rectification under section 161 of the SGST/CGST Act, 2017. Full stop. 148. Acha 148. 148. Appellate authority under section 161. Our rectification order under section 148. Yes, Mr. Kundalia. Allegation of fraud in condonation. He is on condonation only. But after S.K. Chakraborty, which governs us, let him hear the condonation and yes, to the appellate authority for hearing out the condonation on merits, because he simply has said that since it is beyond the condonable period, therefore I cannot. In view of that, in view of the law by which we are bound, he is supposed to hear it on merits, because section 5 has been made specifically applicable by S.K. Chakraborty. They'll make that. They'll make an application. No, but see, there is a Supreme Court judgment, I think, Boidyabhati, Justice Hemant Gupta's, which says that section 5 does not contemplate an application. If the reasons are there in the order, yes. The reasons are not there. You have not given the reasons. No, it's there. Page 48. COVID and all is there. No. Many things. Lack of knowledge, GST compliances, COVID. So many things are there. And what has the appellate authority said? Where is the reason shown by the appellate authority? He has just said that it is time barred. So let him consider that. Let him say it is not sufficient. if you can substantiate it by further লিখে নিন 13 Miss Sanjana Jha, learned advocate on You are appearing on 13 and 17. As 13 and 17 respondents are represented, लिखे वरना नाम क्या लिखे देना. 14. Hmm? Where is your explanation? And how many days delay is there?
As a policy, but what I find saying the power after the first part, that is wrong. Last paragraph, in page 28, there are different not correct. This should not. Although they quote is but I don't
I'm remanding it to them. They will consider the application for condonation of delay again in the light of that division bench judgment. What was the name? Ram Kumar Sinhal. ওই রামকুমার সিনহালের একটা কপি না আমার এই এখানে আপনার ওই
But I am for the petition. Here, my lord, for the assessment year 2021, my lord, income tax challenging the 147 reassessment order prior to the show cause notice and 148 AD order.
147 order, why?
Well, yes, my lord. And the 148 stage, my lord, we have submitted reply that not considered and no personal hearing given, though not applied. But embedded in the act that notice of hearing no, opportunity ought to have given, but that was not given. After that, my lord, show cause notice issued and I submitted reply, not prayed for personal hearing, but they in the order without rejecting my books of accounts, they said that reply considered, but
But
the
assessment
profit
order was passed on 2nd of
January, my lord.
So
Thereafter,
I have filed the writ petition in August.
August, my lord. Thereafter, a penalty order passed, my lord, in the month of June and July.
No, but assessment order should
Yes,
have
yes,
been
yes,
appealed
ma'am.
within 1 month.
Yes, yes, yes.
So
that,
why?
that admittedly, my lord.
Why should I entertain writ petition against assessment order?
Yes, my lord. But that, my lord, only to that respect, my lord, in the 147 stage, my lord, they without
You take
rejecting.
it before the appellate authority.
Yes,
Take
my
it
lord.
before the appellate authority.
Yes,
These
they were-
grounds are available. Why 147?
Yes, my lord. And also, apart from that, I must indicate, my lord, that another I have good merit in my case. Another law point is the Jaufa issue. The Jaufa issue now Supreme Court decided. But as in my good case, I can go to the appeal, my lord. But in that case, my lord, kindly indicate that appellate authority shall not reject the appeal on the ground of limitation, my lord. And there are many orders of our honorable chief judge. I am carrying, my lord. If your lordship regard, then I can submit, my lord.
So
This one order of Mukul Mohanto.
The writ petition has been filed only to go to appeal. Because January, we are in November.
Yes.
My lord,
Filed in August.
this is, my lord, a fish trader and small trader and commission agent of fish Arad, my lord. But he not aware of the portal, depend on the tax consultant, my lord. Para 7-8, my lord, of Mukul Mohanto and para 5 of Indira Trust, my lord. Oh, দিচ্ছি হ্যাঁ দিয়ে দিচ্ছি সরি আমি এই যে as I have good merit in my case also, man. But without rejecting the books of accounts.
Why? What is the explanation for delay?
My lord, that was not mentioned, my lord. I at the time of drafted, my lord, I missed because the department telephoned in the middle of August, my lord. But I immediately filed the writ petition that I missed, my lord, that point.
You file an application for condonation of delay.
Yes, my lord. Yes.
You file an application for condonation of delay.
Yes. But, my lord, the condonation shall be considered by the one line. Otherwise, my lord, they will reject my application.
No, I will not condone the delay. I will say that they will be considering it in the right earnest.
Yes.
And also pre-deposit.
No. The income tax
pre-deposit they will take care.
Not required.
Only for the purpose of stay.
Stay, yes.
Filing appeal.
Yes.
This writ petition has been filed assailing the assessment order date, an assessment order under section 147, read with section 144 and 144B of the Income Tax Act 1951. Full stop. The order of assessment was passed on January 2, 2025. However, the writ petition has been filed on August 26, 2025. In terms of section 246, 246 of the said Act of 1961, an order of assessment passed under section 147 is appealable before the appellate authority, and an appeal to be within time should be filed before the appellate authority within 30 days from the date of communication of such order. Full stop. In view of the judgment of the Honorable Supreme Court in the case of A.B. Venkateswaran versus Bhai Lal Bhai, reported at Amidi 64. Although no specific period of limitation is applicable to writ petitions, still uh, the remedy of writ being one of discretion, a writ court would be justified in refusing to exercise discretion to entertain a writ petition which is inordinately delayed. Full stop. In the facts and circumstances of the case, since an appellate remedy prescribed by the statute uh, uh, provides for a time limit within which the petitioner ought to have approached the appellate authority, and the writ petition has been filed even beyond that time, comma, the writ petition is not entertained, full stop. The petitioner is, however, left free to approach the appellate authority by way of by filing an appeal in terms of section 246 of the said Act of 1961, full stop. The petitioner shall be along with an application, along with an application for condonation of delay in preparing the appeal, full stop. Since the petitioner had challenged the assessment order before this court by way of the writ petition, comma, the appellate authority shall take due notice of the same and shall consider the petitioner's application for condonation of delay in the right earnest. Full stop. Paragraph WPA 20291 of 2025 stands dismissed without any order.
Lordship said in accordance with law.
In the right earnest.
And my lord,
In the right.
assessment year 2021, my lord.
Acha, assessment year 2020. We
And-
for assessment order dated 147 in respect of assessment year 2020.
And my lord, consequential penalty orders.
আচ্ছা, assessment order dated ওখানে একদম উপরে স্টার্টিং এ assessment order dated ওই যেখানে চ্যালেঞ্জটা লিখেছেন হ্যাঁ 2025 না এর উপরে যেখানে লিখেছেন this
My lord, I'm led by Mr. Avro Mojumdar, Your Lordship, in this matter. We are challenging the order under section 148A subsection 3 along with the consequential notice under section 148, Your Lordship. Primarily on two grounds.
48A3.
A3, Your Lordship.
What is this?
As amended by the Finance Act 2024, Your Lordship, from 1st September. The provisions have been changed.
What is there in 148A3?
Well, that is at 148 AD.
AD.
Acha, acha. That has become 3.
Yes.
Yes.
Your Lordship, the petitioner is an individual, Your Lordship, who had entrusted his tax consultant with all the compliances on the income tax portal. Now, regarding assessment year 21-22, when the investigation was started regarding the reassessment proceedings, the DDIT investigation issued a notice under section 133(6) calling for information, and the said notice was forwarded to the tax consultant's email ID along with the petitioner's personal email ID. Thereafter, that was in the month of November 24. Thereafter,
Just a minute. Hey. I am granting him the benefit of the period during which the writ petition was pending. That will help him.
Yes, yes, yes.
You can actually লিখে নিন। The
yes, my lord. The notice under section 133(6) was issued to my personal email ID as well as the consultants. Thereafter, when the reassessment proceedings began with the show cause notice under section 148, subsection 1, the same was not sent to my email address. As a natural corollary, I could not respond and the order came to be passed ex parte. So thereafter, when the order was passed on 18 June, 4 days after the order was passed, the same order along with the notice was served on my email ID, my personal email ID. And that is when on 22nd June, I came to know that the proceedings had been initiated against me. And I could not take part in it. And my consultant never informed me about the proceedings as well, Your Lordship. Your Lordship would
so
kindly...
your consultant was aware about the proceedings, that means.
Your Lordship, regarding the show cause notice, Your Lordship, it is entirely my consultant's fault because my consultant did not inform me about anything. I came to know only on 22nd June when the order was...
Ms. Das, if the consultant is aware, he is your agent, you have vicarious knowledge.
Your Lordship, I would like to rely on the Honorable Supreme Court's judgment in Rafiq and Munshilal, Your Lordship. I cannot be faulted for the laches on part of my consultant, Your Lordship.
Yes. That's the only ground?
The another ground is, Lordship, we were not served with a copy of the sanction order as well. The approval under section 151 that is required, that was also not even served to us. And recently,
Sanction is required to be served.
yes, Your Lordship, recently the Honorable Delhi High Court in TIA Enterprises had held so, and the Supreme Court has as well dismissed the SLP in that matter. And
in this matter, we need instruction because factual matrix is there. Whether the petitioner is saying in his mail address the show cause notice had not been given. Now, from the order, impugned order, it is appearing that the page 52, it is appearing that in response, SSC has not furnished any submission in his regard till date. Hence, it is concluded that SSC has nothing in his possession to explain the issue and has no objection for reopening the similar. Whether the SSC received the email and whether his tax consultant received the email, whether the 151 also given to the SSC
Well, we need
When can you come back with the instructions?
next week, next week any day.
When? Tell me, give me a date.
Next Wednesday.
Next Wednesday.
That is not well.
Uh,
Of the learned counsel appearing for the writ petitioner, I am praying before your lordship to kindly be taken up the matter at 2 p.m. Due to some personal
2
difficulties.
p.m. will be original side.
Then kindly not today. I will inform the same.
Not today.
But I'm applying for the rest.
I'm making it not today simple.
But only thing, there are 3 pages missing in the petition, subject to correction. Oh. The order, my lord, it says 1 to 4, but thereafter there is no pages after page 1.
Then what do I do?
Kindly see, my lord can also check it.
Thank you.
If it is maybe some uploading, it is not with us. Kindly see, my lord. It is written below 1 to 4. Thereafter, my lord, something else has come up. In our page, 49, 50 is something different.
Yes, 1 of 4. Then there's.
Then the order is not there, man.
লিখে নিন তো একটা You are the advocate on record.
I am not being engaged in this matter.
Then ask him to come at 2 then. I'll indicate this and then. Or I'm simply making it not today, on day after tomorrow it will be called again then. It will not today করে রাখো।
I'm for the petitioner. This is GST matter for the second initial period 2018-19, my lord. Here I am challenging the appellate order and prior that all proceedings, because, my lord, issue related that for ITC, I by mistake not claimed in the GST 3B returns, but thereafter, after filing the appeal, before filing the passing the appellate order, there was an extension. I filed the GSTR 9 and claimed all this ITC in GSTR 9 and submitted reply in hearing. Appellate authority simply says that it is not accepted, but by virtue of our honorable division bench judgment, my lord, in the case of Ankit Agarwal, that if ITC claimed in GSTR 9 also, then I am entitled, and in that case also the matter remanded to the adjudication for fresh, my lord. I am drawing your lordship kind attention, and one important point, my lord, after the appellate order, before filing of appeal, I self-assessed the tax, and 83,608 I paid before filing the writ petition, and balance amount 3,54,000 that was not payable by me. For this reason, I against the appellate order.
Mr. Chakraborty, can this be decided without affidavits?
I don't think so. It has to be. And an opportunity, what he says is a principle of Order 41, Rule 27. Additional evidence at the stage of appellate order.
No,
that was not
in tax
before the
proceedings,
adjudication. No, I'm just drawing inference. I'm saying that whatever my learned senior friend is saying was not before the adjudicating authority. Now, whether the appellate authority could go beyond the documents which was placed or something like that, but this has to be an affidavit. And but here he has paid. A part of it is admitted. What my learned friend says, he has paid part of it, and the remaining part he is.
Let them file affidavits then.
My lord, in similar circumstances, my lord, that matter remanded to the adjudication, because in that case also adjudication was not done properly. May I submit that judgment, my lord?
But before adjudicating authority have placed the facts, this fact was not there before the
Records were there before the authorities below.
Yes, yes, all the records available in the portal. No. But the filing of annual return, that was very much available before the adjudication authority.
That is what I'm saying. That was not placed, possibly.
And
not
what was the fact of this case? In this case, it was there.
Copy. My lord, that fact, my lord, starts from para 3, my lord. It's similar to me in my case, my lord, applicable. That was ITC on cess, my ITC on IGST. My learned friend appears.
I'll be relying on para 7, para 6, para is the issue of revenue neutral. Says because there was
No. It is actually that was cess, it is IGST.
Mr. Chakraborty, you also go through the papers. I will also go through it.
Yes.
Let us not do it in a
so
hurry.
many orders are passed, but I also.
And my lord, for your lordship convenience, my lord, just one look, my lord, kind look, my lord, at annual return page, my lord, starting page 105.
105.
Or 103, starting page 103.
103.
This is annual return. And operative part, my lord, 105, page 105, 6A and B.
105.
105. After the middle portion, details of ITC, lordship got for the financial year 6A. left side 6A, 6B. May I read, my lord, this column? That total amount of ITC availed through 3B. This is SGST, CGST, and IGST. Thereafter, my lord, B. Other than supplies liable to reverse charge include in from SEZ inputs CGST, SGST, and IGST. There is difference of A and B 3,54,457. That is, my lord, that amount I showed in the return, my lord, annual return, and in the reply, my lord, before the appellate authority at page 140, my lord. 140,141, my lord. That I stated all my facts in this reply, my lord, before the appellate authority.
And that is with the appellate authority.
Appellate authority.
So that's what I was saying.
Because, my lord, the time for filing of annual return extended. That notification I also attached. For your lordship, kind look, my lord. For 140, 141.
140.
Reply before the appellate authority.
Yes.
That all the facts, my lord, here in 2 pages I have.
So you had indicated all this
Yes,
before
yes,
the appellate authority.
yes.
This
And,
is
my
my
lord,
question.
the related notification is that, my lord, page,
Please,
my
Mr.
lord.
Chakravarti, if all the documents which were there before the adjudicating authority
No,
have
not
been
there
brought.
before appellate authority. Adjudicating
No, if the documents which were there before the adjudicating authority
was not there, my lord. Kindly see, subject to correction, my lord. 86.
No, but he's supposed to look into those documents.
page
Appeal is all
86,
about that.
my lord, subject to correction. This 9C was filed on 21st March 2025. The date is page 111. This 9, what my learned friend is showing. Subject to correction. এই যেটা তুমি দেখালে 9C দেখালে
Notification, my lord, at
no, that's what I'm saying.
notification at page 101.
That is 21st March. Well, this was, and the adjudicating order was in 2024. Page 110, 111. Kindly see the date. So the return was filed subsequently. It was never before the adjudicating authority. Could
My lord,
not have been.
yes, my
It
learned
could not
friend,
have been. That's what I'm saying.
learned friend, correct, but for that support my page 101, my lord, because CBIC extended the date.
No, that is what I'm. No, that there is no.
Page 101, 102, my lord.
There's no dispute that there was an extension. Rule 80 was
No,
extended.
now then, Mr. Chakravarti, if there
It
is
can
an
go back to
extension.
the appellate authority. It can go back to the appellate authority because
Yes.
I say adjudicating authority did not have a chance because he did not file it on that date.
Right. When did the extension come?
Extension page 101, my lord. But that also mentioned in the reply, my lord. 101 is the central notification and 102 is the, my lord, state notification.
Very well. I will also apply my mind.
Yes.
It should come back to the appellate authority is my prima facie view.
But I also
Because in the facts of this case, if documents which were not before the adjudicating authority at a particular point of time could be brought before the appellate authority because the law permitted it subsequent to the adjudication.
Absolutely.
Then in that case, appellate authority was at least bound because an appellate authority will have all powers of the original authority.
Absolutely. If extension was valid, my lord, he ought to have
So the
taken
appellate
into
authority should take into
Yes.
consideration. How has the appellate authority dealt with this?
Yes, my lord. That, my lord, at page appellate order at page, my lord, starting page 144 and operative part, my lord, 147.
147.
After the middle portion, my lord, the AR middle portion from last second para, my lord. In this point, may I read?
AR in this point.
Yes, content that appellant while submitting return 3B committed mistake by uploading nil return such and such. The appellant had rectified the mistake and reconciled the same by filing annual return such and such, such and such. So, my lord, in this fact already stated, but they have not dealt, my lord, in the subsequent para, my lord. And 148, my lord. Next page, my lord.
Just. At page 105, 6A, total amount of tax input credit availed through form GSTR 3B.
Yes. 10,35,956 and their annual return is 13,09,000. For difference is 354,457. Same figure, madam.
Difference is
3,54,457.99. That is disallowed, my lord.
And how do you reconcile this with the adjudicating authority's order?
No, my lord. At the time of adjudication, I could not file the annual return as the date expired. Subsequently, government to
Where
facilitate
is the adjudicating authority's order?
Yes,
shown?
my lord. At the adjudication order, my lord, at page 79, starting page.
Page 79. Yes.
Order actually start from 83.
No, very well. This reasoning part is at 79.
Yes.
Yes.
84 middle portion, second para, my lord. That ITC, that second para, my lord, accordingly proceeding under section 73, page 84.
84. Yes.
That second para, it is written that accordingly proceeding such and such, such and such, such and such, liability adjustment through accumulated IGC ITC, but not acceptable at RTP claimed IGST 1890 after the due date of 16/4.
Now
But
this after due date.
no, my lord, this 16/4, now another points come, my lord, that 16/4 is not applicable in my case. They later accepted, because in my case, when I claimed my return in due time means, my lord, next year within September.
Extended time.
No, within due date I filed the main return. But 16/4 is for if I file the return after that period of time, claim the ITC, then 16/4 applicable. But in the appellate order, that was not discussed. 16/4 issue already resolved. That they cannot. But only now in this respect, only that amount is required. 83,000 already have paid before the filing of writ petition. That I mentioned in the paragraph of the writ petition. I self-assessed and paid.
This would possibly require some, because the factual something.
No, in this case, my lord, that Ankit Agarwal case, my lord, that adjudication authority, my understanding, I may be wrong, my lord, adjudication authority more well equipped to examine the fact than the appellate authority. That is why our Honorable Chief Justice order, my lord, that matter remanded even after the appellate order, it was remanded to the adjudication, madam.
No, that was the one which you have shown is not appellate order. It's adjudication order. Adjudication order was challenged.
Oh, madam, sorry, I missed, madam.
Yes, it was not adjudicated.
And another judgment I attached with the writ petition, Madras High Court, page number 142.
142.
I will leave it to your lordship, my lord. Your lordship will decide that.
Difference is here when it says that GSTR 9 was not at all considered. Here there are some references in the appellate order. But
Madras High Court also, my lord, remanded to the adjudication, my lord. Page 142.
And where does the appellate authority deal with GSTR 9?
Page, my lord, at
147.
147. They are saying middle portion, after the middle portion,
The
my lord,
appellant rectified the mistake and reconciled the same by filing annual returns.
annual
in
return,
GSTR
right,
9.
right. But not stated that why annual return not acceptable, it is not mentioned. Logic not given properly. Only, my lord, in the next page, the appellant contended, it happened that not claim, next page, my lord. Third para. Inward credit to the tune of 354,457. Your lordship got third para, my lord. 148, page 148. The appellant contended. Head of IGST 3B, however, rightly claimed the both outward inward in the credit period 18 such and such August 19. The plea of devoid logic, fact, proper explanation. I explained in my reply. And by virtue of notification, I entitled, I claimed in the GSTR 9 return. 9 is annual return under section 44.
All right, I will also go through it.
Yes,
and
yes.
then
But I'll also take into consideration.
I may require clarifications from both of you.
Yes, madam.
Uh,
The prayer for condonation of delay in filing the appeal under section 107 has been, my lord, refused. Ultimate observation is that, my lord, the authority has no authority. Statute does not permit me to accept, page 54, impugned order, last line. The statute does not permit me to accept the instant appeal application.
no, 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 it's not right.
It's not. And my the Kerala High Court
Permission
judgment.
now, because of SK Chakraborty, permission statute permits.
True. I'm with my learned friend. Lordship, kindly see the impugned order. The impugned order. No. Lordship, kindly see the impugned order. The impugned order starts from, Lordship, kindly come to page 53.
Yes.
If your Lordship kindly see, the order categorically records that in view of, may I place that order? Page
Yes,
53.
I'm at it.
SK Chakraborty has been considered.
Yes, it has been referred.
So after considering, he said that then I am going into the merit of your delay. Give me some document. First, we have issued notice. Then, Lordship, we have heard him on merit. Then we have taken SK Chakraborty on record. Then we said that we are bound to hear you. Then you give me your document. I will scrutiny and I will see. Then, Lordship, we have applied the other two judgment because Lordship knows the delay has to be properly explained. And it is a fiscal statute, more strictly has to be explained. Then, Lordship, we have given a liberal interpretation that give me some document which will connect 1 month bed rest, because the total delay is of 9 months something, more than 200 days. So, Lordship, around 200 days delay. So, we have given him a say that you give me something on which we can clutch upon, because we want to do it on merit. Then, Lordship, that also he could not.
Yes, yes, I produced the certificate, medical certificate. I have annexed it, page 45.
Let's read that order, page 53 and 54.
Well, at page 40, page 45, my lord, you will find my prayer, where I have prayed for condonation of delay.
Page 53 I have read.
Page 53 is appearing before me on this.
Well, at page 45,
Stated that due to, now kindly come
Now
to
he
the memo of appeal.
Page
Page 42 is the memo of appeal.
Mr. Banerjee says he produced a medical certificate and Xerox copies of some prescriptions against his claim.
Yes, now we have
why this medical certificate and the prescriptions are not entertainable, there is no reason. There is no reason. Where is the reason? Because thereafter, yes, medical certificate
against
and
his claim.
prescription.
Now we are
No, Mr. Banerjee, please answer the query of the court. Thereafter, he goes into judgments. Where is the consideration of the medical certificate and the prescriptions? He should have said that I am not in a position to believe this medical certificate, or these Xerox copies of prescriptions are not acceptable to me because of 1, 2, 3 several reasons. No reason has been given. He has gone on elaborating on what Supreme Court has said, what High Court has said. These are all principles, and then he comes and says there is no plausible explanation. If he is ill, what more can he produce in support of his illness rather than medical certificate and prescription? He has done that. So
today he has produced before your lordship.
No, he has done that here before him. Let him consider it. Let him consider it.
And whatever he produced in the court below,
yes,
he has also produced before your lordship today.
Yes.
Lordship, let's see those documents once.
Yes.
If that shocks our conscience that it should have been considered below, then lordship is
very well.
Now, lordship, kindly come to the medical.
Yes.
Page medical. Yes, lordship. The medical document starts from page 46 end.
Page 47.
Lordship, kindly see. Let's see. Lordship, kindly try to make out the ailment, lordship.
Very well, Mr.
And ultimate certificate.
I will not stand in the way, lordship. This is my duty only to point out local MBBS doctor. I mean, these are not being said in the order. Should I understand? Lordship, can you see?
Let him deal with it once again.
Lordship,
let him give the reasons.
Local doctors.
Let him give the reasons.
Cannot,
I'm not condoning the delay. I am not condoning the delay. Let him deal with this in a manner where how a judicial authority should. Let him deal with it. This writ petition. Only thing, there is a division bench at 3. There is a division bench at 3, of which I am a part. So I'll rise at around 2:50.
Release all other matters for it. That will continue.
You will continue to 2:50. Then
Release all.
Matter has been finally heard because my learned said that this matter can be decided finally on
without
no
affidavits.
disputed question of that. So it is final.
All are disputed questions.
So it is finally we are arguing the matter.
Yes, it's on law points.
On law.
Or then release all other ones.
Pull it.
If the quantity matter item number 1, all other matter are released for the day.
No, item has been called on. What do you want to mention?
Actually, I wanted to mention for inclusion of a hearing matter.
Hearing matter, I have said I am not taking this week at least. Don't mention hearing matters. Lot of motions are there. Let me get away with the motion. Try your luck next week if I permit. Let us see how I proceed this week.
I was answering on that.
Yes, your point was that this notification was never made public. Therefore, nobody was aware of this notification. It was not brought to the knowledge of the public. And therefore, if something is not within your knowledge, you cannot be held to that.
Yes.
That
And one thing, and one, I can't be held, and there is another part of it that it can't be taken as a law. Because
correct.
Law is the one which is known to everybody by promulgation or by the procedure known to law.
Yes,
so
yes.
The procedure known to law under the General Clauses Act is there that it should be in the Gazette, in the statute, it should be published in the Gazette. So the procedure known and to everybody is it should be properly gazetted. And since I was touching the point with this point, before that I will try to replenish one point. If it was something which was in the notification said that I should give country of origin as a multi-origin. That was the notification. Where I should say this as a multi-origin. But that notification requires for me. In the last but one line, it says I should declare it as a multi-origin thing.
Just.
So now, I'm really replenishing this point which I have placed it yesterday also. That all the terms which are being used for the purpose of import and export had a statutory meaning. They have to abide by the law, operating laws. And the operating laws also provide that what would be the country of origin and the manner in which I have to comply with. So country of origin is something which I can't, any authority can't say something new unless he provides in the statute a deeming basin that or defines it, that what does it mean. And then only if we ask the person to follow that, then that it becomes which other person to follow point of law or legal terminology. Multi-origin is not a term which is known under the Customs Act or any standard. What the Act says about this origin of the product, a few judgment also are compiled for ease of argument, and which I am giving one to my director. And if Malvi kindly run to page 55
of the compilation.
Of the compilation.
Yes.
This is a notification issued under the Customs Act, which says how I have to declare my country of origin. Customs Administration of Rules of Origin under Trade Agreement Rules 2020, which was being notified. then Marathi kind of sees that definition clause, rules of origin, the
Here in this case, the country of origin was what? Kenya.
it was India. I was exporter. It was India.
No, you cited page 61 last day.
That's page 55.
Page 61 also you showed last day, yesterday.
But this is for the first time now. But from the brief,
No, from the brief last day you showed page 61 for what purpose then? From the brief.
Number 61, I have placed it that this is the detail of my input in my export product. But when
Because there also you have stressed on countries of origin.
yes, but when I am dealing with the tea licensing authority, who is the tea they have prescribed their form. This is the form 3 under the statutory form. This says that you have to describe whatever the inputs which you have used for the manufactured final product.
So the input which you have used in the export product,
yes,
the country of origin of the input product being in the material being input is Kenya.
Part of the goods which I have imported from Kenya, I have processed it in my factory. I have put it in indigenous goods. I have put
So roughly speaking, one of the raw materials for the finished product or forever the export if the product sought to be imported is one which has its origin in Kenya.
So I am giving full details of even reference.
So what was the purpose of citing this page 61?
But because this is, I was this when it was so-called notice and to say that that you have not complied with the requirement that you should mention country of origin as multi-origin. I have declared in my customs document country of origin India because final processing is done in India. There I am to abide by the provisions of Customs Act, Foreign Trade Development Regulation Act, and other international law governing the field. So that is not a document relating to them. This is a document relating to me and the custom where I have mentioned country of origin India because final processing is done in India. So it will be a product in India. How I am to classify my products for the purpose of Customs Act is being provided under the rules also. That was I placed it that I have to comply with regulations governing custom, foreign trade development, FEMA and all while doing one export of tea. In this respect, I have said this department knew it, what I am using. They have assessed all my civil bills, all my documents, applications. They grant permission of each export, each consignment. When they are exporting and assessing each consignment, then there is nothing that they are not aware of anything what I am doing. So my invoice was showing, which I had showed the invoice. I might show the invoice back again.
Yes, page 63, you have shown that.
Invoice are shown in the body of the license description of goods. I have mentioned Indian black tea blended with imported. This fact I have mentioned imported here used in paper sacks with plastic panelized stretch with etc. Then at the top,
This imported you have used because of that Kenyan raw material.
and with this I have given percentage input document and all. Then where they are quarreling with is this country of original goods where I have placed India.
Yes.
Now they are quarreling with me this.
They say that it should be multi-origin.
It should be multi-origin.
It should be multi-origin, to which your answer is that since you have ultimately obtained the product in finished shape so that it can be exported in India, I mean the finishing of the product you have made the product ready for export in India, therefore the country of origin of the product to be exported is India. Because the raw material which you have imported is not the product which is to be exported. The product will be exportable only if you process it and it comes to say for example this pencil is a product which you have imported. Now, after it being coated with gold, silver, and so many other things, it becomes product B, which becomes an exportable product by you. Now, it is this exportable product which has been ultimately prepared and given birth to in India by using this raw material which has a Kenyan origin. So therefore, this product has its origin in India, and therefore country of origin for this product is India. This is what you mean to say.
But I would like to give a better example. My example is like this. I import granules, plastic granules, and thereafter I make it a glass. So what I am exporting is not granule, I am exporting
Correct.
and country of origin of that glass is
India.
Is India.
That is what I wanted to say, that the exportable product has actually been produced in India using maybe raw materials from different countries, but that does not make it a multi-origin product. It remains a product produced in India. Taken.
Now, when there is a interplay of the various acts, so under the Act which I am being covered, there is no such provision except that letter which we have never seen. We have seen it only after the issue of the Supreme Court that this is a this was a notification which nobody had seen like it. We have flouted. That was a chance by not mentioning. My first point was that all my export documents have gone under your vetting and after assessment done, no objection taken. While vetting, you have seen my invoices, you have seen all my documents, you have verified each and every document, inspected the goods. Goods are opened, packaged, tested. Every consignment is tested. And only when it is approved by the department, the consignment goes from India. So this being followed, there was no complaint. Department was also not aware. Anything, nobody was aware of this. It was going on. And in fact, in 2024, in the parliament, when the tea export matter was being debated, Indian spurt of the Indian export in the tea market was celebrated. Where I am one of the biggest exporters in India of the tea, where my teas are being sold in UK and in US and in the top Harrods also. I have a counter of my goods where my tea is being sold, my packaged tea is being sold. So well, there was no such law under this thing should be done. So what I was to actually do under this, but for this I was brought to attention page 55. What the statutes? My third very said I won't go along with this page 57. I will be little brief now because this is a peripheral thing. Section 1. That is in reference to the Rule 4 origin related information to be purchased by importer or exporter, whatever. What I am to as a country of origin, what is to be said? In importer making a claim for preferential duty is required to process sufficient information as regards the manner in which country of origin criteria, including the regional value content, product specified criteria specified in the rules of origin in the trade agreements are stated. So now what is being stated is this product will be in India if it is wholly obtained. In that case, one has to put it as goods wholly obtained. If it is something which you are partly obtaining, then you mention it that it is being used, not this when I am doing it, claiming trade benefit. So country of origin is a concept which one has to follow under the Customs Act, etc. Then any law which is repugnant to that Customs Act. If I say this, that this will be violation of the act, when there is no statute operating with non-obstant, then it is otherwise wrong. Because there is no such provision that I am to declare as multi-origin, which is not a term under any act. If we kindly see multi-origin as a term under the English, it has no meaning. If it has no meaning, I take it like alpha. Again, going to see. In that case, I have to give a dealing fiction of alpha. What does it mean? Multi-origin is what? I don't know. Multi-origin has to be explained. What is multi-origin? It has to be defined. What is multi-origin has to be defined by a statute. Then a dealing fiction has to be created. Then it has to be non-obscene. And it has to be only in relation.
And where have they said that you should have said that it is multi-origin?
Multi-origin is in the so-called notice.
So-called notice.
That they have said that you have declared it as a multi. At page 109.
Yes, page 108. Exported as multi-origin tea.
Instead of
Multi-origin. Got it.
I asked you myself, what is the meaning of multi? I have no answer. Today, I have seen, my lord, the dictionary. I found multi-complex, multi-buildings, multi-flats, but I did not find multi.
Origin should be one, according to you. Origin should be one.
Multi-origin should be an English word. It should have some meaning. If
No, meaning it will have if because multi-origin is not one word. It's actually two words. And both words taken together do convey a meaning, something which has many origins.
if something has many origin, is something which should be a term under a statute or term under
Yes,
English.
that
It
is
should be English.
yes.
It should be English.
That it is, but it is
Not
whether
there,
it
it's
is
not there.
no that it is, it makes sense, but whether it is statutory or not, that is a point.
I'm just literally I'm saying when I was looking into the multi, I found multi-complex, multi-building, multi-this. I don't find multi-goods in this dictionary, etc. Then I search Google. Then is there anything like
Google must have given an
No,
answer.
that also doesn't have. They say is not there. If is not there. Then one I had seen then Chat GPT. Then Chat GPT says that it could be something where things of some abstract thing will be of various things, various resources, etc. That it has anything to do with the exports or with the country or with the same country is not there. But what I understand this, when the soap was noticed by issued, this notification was not there. Because notification has to be correct. This notification, you can see the date is page 42. And if page 42, this notification is half English done. Sentences not completed. Can it be something which was at the stage of notification stage? It would be at the draft stage. It has to how a notification, a long-dated process goes. First, a draft is made, the draft is approved, then draft is shown to the for purpose of comments. There are stages following which a law, whether notification, etc., takes place. So, whether section 30 not there had all crossed already state 560. No, appear not this has been done by secretary and kept it in his drawer. And Sunday, when boss called that I have given dictation, where is that? Then he brought out. Then he says, not published. Okay, so called will be soon. I will let me make it. You know, okay, like just like that. Otherwise, how come it can be 30 missing and 3 and 5, and how could it go cross 4 important stages where level of going secretary, level of going at various level, and one copy has to be sent to Parliament also. This ministry also of this. This has gone like this, and another notification is also same, though different, same day, same. 30 is not there. But this cast a doubt whether it was any time created. Little bit rightly, I can only say, but none of has been able to point out whether it was invented or it was discovered. It was not invented. One invented it or discovered it when we, after the so-called notice, when we challenged. They will go to common sense. A statute making process is such an important process, a subordinate legislation, which will become a law within the meaning of the Constitution of India. Article 245, 246, Article 13. All rules have to abide by the anything contrary to this, our right is void. So law means law which is made in accordance with law, with the procedure. That is the law. Is it this anything said in this letter is the law? Then it has to have some force. No, but a few judgments on this. In this comparison, Marudi can be
Have we got it recorded anywhere that the hearing will be concluded without affidavits?
This was our understanding that day one.
We will record it today then, because
No such record.
No, sir.
then we'll today record that.
Yes.
Because it should be there in the records.
Otherwise, the board will take a appeal. Somebody will be there and take no opportunity was record.
Yes, one will kindly see the paragraph 15 at page 15. That's the Supreme Court, both inequality, justifiability, the old judgment,
Yes, paragraph.
paragraph 15, page 15.
Yes.
There can be no doubt about the proposition that where a law, whether parliamentary or subordinate, demands compliance, those are not governed, those are governed, and those that are governed must be notified directly or reliably of the law and all changes and additions made to it by various persons. Whether law is viewed from the standpoint of the conscientious good man seeking to abide by the law, or from the standpoint of Justice Holmes, unconscientious bad man seeking to avoid the law, law must be known. That is to say, it must be so made that it can be known. And this is light-hearted. We are saying it that, but this is also in our manuscript. In Manusmriti, what has been said is this: when the Rajan makes the law, and he's saying in English that Yathapiti, he has to notify to the all public, otherwise it is not a law. So, whatever is in the Latin, everything is in that Manusmriti.
Yes, yes,
Everything
yes,
is there in
yes,
the
I have seen that.
We know that the delegated or subordinate legislation is all pervasive, and that there is hardly any field of activity where governance by delegated or subordinate legislative power is not as important, if not more important than governance by parliamentary legislation. But unlike parliamentary legislation, which is publicly made, delegated or subordinate legislation is often made unobtrusively in the chambers of ministers, the secretary or to the government or other official dignitaries. It is therefore necessary that subordinate legislation, in order to take effect, must be published or promulgated in some suitable manner. Whether such publication or promulgation prescribed by the parent statute or not, when it is not there, it has to be done. It will then take effect from the date of such publication or promulgation. Where the parent statute prescribes the mode of publication or promulgation, that code must be followed. Where the parent statute is silent, but the subordinate legislation itself prescribes the manner of publication, such mode of publication may be sufficient. Here it is being given that it should be gazette notice. If reasonable, if the subordinate legislation does not prescribe the mode of publication, or if the subordinate legislation prescribes a plainly unreasonable mode of publication, it will take effect only when it is published through the customary recognized official channel, namely the official gazette or some other reasonable mode of publication. There may be subordinate legislation which is concerning few individuals. That is so since when we have placed it, my lord has argued that this portion of this was not required to be
Published.
That was his argument. So mine was that this is very much covered because it very much mentions that it is pursuant to the 32, regulation 34, and all regulations put in the 34 has to be notified under 32. So it is specifically clear nonetheless. But even if there was some side way to go, that is also blocked by teachers. But even if it is not there, if it is to be a law, it is to be complied with, it has to be published, and if there is no mode given, then it should be gazetted. But there was another judgment of Supreme Court in Haryana versus State of Rajasthan, just page 21. Well, the Supreme Court itself notified dealing with the matter. It said this that there was a penalty imposed of 50,000 on a person for possessing opium. And at the time when this they said that the Opium Act, which was made in the year 1922 by Jaipur Maharashtra, that was in operation, which was never notified to the person concerned, and nobody was aware of it, and it was some resolution in Raj Sabha. I think there Raja's meeting which has taken place, anybody having this more than this will be punished with 50 rupees at that time, and this. So person was being penalized for that, for having certain opium.
There was no written law.
On the oral, and the person challenged it. The High Court granted plea to appeal. This is a very interesting question. And the Supreme Court decided the matter. The paragraph 9, page 27. Natural justice requires that before a law can become operative, it must be promulgated at office. It must be a broadcast in some recognizable way so that all men may know what it is. Or at the very least, there must be some special rule or regulation or customary channel or through which such knowledge can be acquired with the exercise of due and reasonable diligence. The thought that the decision reached in the secret recesses of chambers to which the public have no access and to which even their accredited representative have no access and of which they can normally know nothing, can nevertheless affect their life. This exactly happened today. What has happened in 1922, the same thing is reincarnated. Such a law-abiding company, I could give this declaration in the customs check with the rider as required under the T Act.
Justice Bose's judgment, Vivian Bose.
Yes, well, this is marvelous. And
the language itself,
yes.
the earlier one was Justice Chinnappa Reddy.
Yes,
All
and one, if we get the Krishna's judgment, then it is something. Then it is
half every sentence you'll have to open dictionary. At least I have.
And language and poetic something presentation.
Fantastic.
One
Unmatchable.
Is getting entertainment, knowledge, and everything when reading Krishna's.
Superb.
It shocks his consent. In absence, therefore, any law, rule, regulation, or custom behold that is law cannot come in promulgation, publication of some reasonable sort essential. So that is really then thereafter they have followed it and given some English judgment, paragraph 13, French judgment in other international law, all have been quoted after this paragraph. Then, this is one of the celebrated judgment also, for Jeevan Reddy as page 27, ITC Bhadrachalam. This was also really a very interesting case where the certain notification of conversion relating to agriculture, non-agriculture banks were made without notification. Then in that context, we will paragraph 13. The first question which
Yes.
to answer is whether publication of the exemption notification on the government as required by 11.1 of the mandatory or direct. 11.1 requires that an order made thereunder should be published in the Andhra Pradesh Gazette must be set out the grounds for granting the there is some same thing is being mentioned, and when you come to page 646, and it's very much clear after B on the right hand side when it was getting clear. In other words, publication of an order or rule is the official, irrefutable affirmation that a particular order or rule is made on a particular day. Whether the order rule takes effect from the date of publication and is made by a particular authority. It is also the official version of the order or rule. But here I am reading this. But today, I am able to say while addressing the lordship, I don't know when the date is 21.
When it took effect.
No, when it was really signed, I don't know. 21 dictation given in 21, 22 vetted, 23 sent to ministry somewhere, came down with corrections and forgotten, and came up after having my challenge to the so-called notice that there is no such notice. But this notification, we have been, after the so-called notice, we have been looking around. We are not getting, ultimately we ask them that where is that notification? And they did not tell us that it has been notified. So when the matter was moved, I asked purpose. It does justice. Not kindly ask my arrangement to explain whether it has been notified. This much. Arrangement took time for me that I have to take time. And the next day he says it has been notified.
Not published in the website.
Two
things are.
That's what
One is not notification, another is publication.
Yes.
Whether it is notified or how the line of could get access of this notification. He has annexed the notification. He himself annexed those two notifications. Therefore, it was notified, but it was not published in the official gazette. Now the question is whether the publication is required or not. That is to be settled by your lordship. It was notified. There is no doubt about that.
Mr. Tiwari.
Yes.
Order dated July 29, 2025.
Yes.
See the recording. You have a copy?
Yes. Yes, ma'am.
Please
Today,
read
such and such candidly submit the notification both dated such and such from which form the basis for issuing the so-called dated 8th of May 2025 have not been notified. But there must be some, with deepest of respect, it was notified, but it was not published in the official. It is the case of my learned friend. What is my learned friend's case? My learned friend's case is this: it was not published in the official gazette. He is saying that para 32 has not been followed. This is his case. Well, if it is not notified, how could he annex those two notifications? Well, this simple thing. Well, notification and publication, two are different things.
Not different.
Yeah, absolutely different things. How could he?
This is my answer. He will be getting full time.
No, because there is
clarifying
recording in the order. That is why I wanted this to be
Yes,
clarified.
yes.
That means notification means lawful notification.
No, Milad, there is a lot of hell and heaven difference between the notification and publication.
But there's this.
Milad, Milad, it is notified. It is there in the T-Board's official website. Milad, just one page. Milad, before my learned friend starts again, Milad, kindly text Milad page 42 once. Your lordship would get it, Milad. This is a notification dated 22nd of December 2021. Now it was forwarded to all producers associations, all exporter associations, all buyers associations. Copy to executive director and all these things. And it is also in the official website of the T-Board. So notification is there, but the fact remains it was not published. My learned friend is saying, making the submissions, notification, all notifications are there.
In the office, how? I am asking the question to myself.
And
How
when was this uploaded on the website?
on the very can you see? On the very same day it was uploaded. How my learned friend could get access of this notification? I am asking the question to myself. He has annexed it. It is not my case that I have supplied him. He has annexed it. Now he is making a point with notification. But notification and publication of notification in the official gazette, two things are absolutely different. But I'll make my submission. Let my lecturer conclude.
Is progressing. Answering at every situation. This first situation, first answer was this before the court, which was recorded also, on which my friend was asked to elaborate. He said that legislation 34. Legislation 34. If I am wrong, my friend will say that power to issue directive.
Page?
Supplementary regulation based supplementary page 20.
Page 24. Yes. Yes, power to issue
directives by the got that, huh? Then minority kindly come 32. In case of an order of general nature, he argued that this order is not a directive. A directive is required to be gazetted under the no. Sorry, it is an order. It is to be gazetted. If it is a directive,
not
yes. That was the submission. Since it was a directive under 34, it may not be published. It does not come within the domain of this one.
Yes.
It was never a dispute that this was put in the court, etc.
That is what he's saying today also. He says that it was never published in the official gazette, but the notification took effect because of notification. That is what he said.
He says that it was an order, general nature. Order, it was there. So that was my ultimate contention. That it has been put in the gazette, it has been put in their website, etc. This is really, when this judgment says that it can come as a shock to
But is there any quarrel on this, that it was put on the website?
No, we have no knowledge of this. We have no knowledge of this. That whether we have no knowledge that this is a notification which was at any time within the domain of the public. When it was put, when it was done, nobody knows about it. And saying this that it is in public, it's my domain, it was put in my domain, etc. About this is really no answer, and that is why it is a law. Law has to be made known in the procedure known. It can't be done in any other manner. If Parliament makes law, then it has to be told in the manner in which statute provides. If statute provides that it has to be gazetted, it has to be gazetted. By saying this, that I have put it in my Indian
That will not suffice.
My arrangement is only going to say this, that my putting it in the site without anything which is being notified in accordance with law is being put in the website. But this thing really is very shocking. A government's a law framed by the government that is not being notified and only put in the website, and everybody will see that it will have to go by. Then while dealing with one has to write an undertaking that I have read with all the notifications put in my website, and I undertake to follow it. When we buy the revenue, there's a line. I abide by all the regulations of then it should happen there like that. So law, application of law is in the manner known. It is not on the wisdom of my learned friend and his eloquence that he can change situation from A to B like Kishi Sarkar. I am just like that from here. It is shocked to me that it was in the website and it was in the so.
Yes.
Well, that is precisely the reason why these paragraphs were inserted. Courts have presumed general availability judicial notice of what is published. Unlike publication in newspaper, which has to be proved as impact and evidence could arise in with respect to precise language or contents of the rule or order, if such rule or order is not published in the availability, it would become necessary to refer to the original itself involving the amount of. For these reasons, what they are saying that we say that there is publication. But to really block the argument which is being made today by my right, they could have, I say, could
Page 39.
Yes.
39 of the compilation.
Yes, yes.
First line, the object of publication.
Yes, object of the publication is not merely to give information to the public. Official gazette, as the very name indicates, is an official document.
So mere giving information will not do.
Information won't do. It has to be made official. And a breach of it can make an establishment crumble down. That I have violated the law. Not in the international law.
Then it says publication of an order or rule in the Gazette is the official confirmation of making such an order or rule.
And then they say the purpose of it, they write it at the purpose. And perhaps, they were conscious of this, that one day, Tiwari can and this will be the perfect answer. Now, can we come to General Clauses Act, which is at page 50.
Okay.
And can we come at page 50? Here it is being given. Suppose if it is said that it was a rule, ordinance, it wants to make a distinction between order or directive, etc. Whatever. Provisions applicable to making of rules or bylaws after previous publication. Then this will be kindly come to whereby the Central Act or regulation give power to make rules or bylaws express subject to the condition of bylaws after previous applying 1 5. Publication the official gazette of a rule or bylaws was put to have been made in excess the power to make bylaws after previous publication shall be conclusive proof that rule or bylaw has been made. So even the General Clauses Act also takes care of this issue. So but this is on my point number 1. So now I am coming to my point number 2 about that the local notice when or page 109.
Yes.
That I have declared multi-origin last paragraph in view of the above, you are hereby directed to show good in writing in 7 days from the receipt of this letter, explaining as to why action cannot be paragraph 27 of the distribution and execution of this is 27 comes here, there's some supplementary activity. Page 8.
Yes.
This is in exercise of power conferred by subsidiary and 5 of section 30 of that. And 27 is suspension or cancellation of criminal license or permanent this. Then they say that it is done for violation of G, that is 27(1)G, violation of any provisions of this order.
Yes.
And is this.
Yes.
Section 30 of the DA.
Section 30.
The Act has several chapters. Chapter 6 is controlled by the central government. Chapter 4 at page 25 is control over export of tea. Page 25.
Section 30 is planting of tea.
Chapter 6, page 30.
Page 13.
Chapter controlled by the central government.
Yes.
Then Malone can read section 30. I'm reading it.
Power to control price.
Price and distribution of tea and tea waste. This is the power and tea for this purpose.
I have a division bench at 3. I'll have to go to the main building. Yes, we'll continue. Mr. Tiwari, would you not like to bring on record when it was notified or when it was? You bring it on record by way of a small affidavit.
Small.
That will help all of us because it will be something will be there on record.
Yes. And not only that, Milord, I just show one thing. Other tea companies, when they are exporting, they are writing country of origin of goods, multi-country origin. Well, I'll show all these things. And not only that, the notification, which my learned friend is saying, notification, it was sent by mail to my learned friend's line also. I'll press. Give me 7 days time, I'll file an opposition. Well, I'll just show.
Because we are in the midst of hearing, I would not like to stall the hearing because of the opposition, but it should come.
I'll file. But let
it
my
will be
learned
better, Mr. Mehta. It will be better for all of us.
Yes. Well,
so that things are clear and in order.
Yes. Give me 7 days time, I will file.
But we can continue with this. It is something a matter which discontinuing the hearing will be really missing the link of this because we are almost in a height of this. I am arguing with ultra virus point of this because of this. So it's such a very small thing, and where that is, this is something what he says he has sent me a season mail.
I can show it now. Here and now I can show it.
Here and now he can show that. And here and now I can here and now I can deny that.
This is
here and now I can deny that.
The law officer is here.
That is what the law says, that it is a law, it has to be gazetted. So but this dispute and this contention.
Mr. Mehta, if next week I hear it, it won't be a problem.
By Monday,
by that time he'll file that.
By Monday,
but I let him file it because he wants file. Day after tomorrow, I continue this part of ultravirus.
No, the problem is day after tomorrow and the day thereafter. That is Thursday, Friday. Fridays I'll be taking up assigned matters. So Friday is ruled out, and Thursday those Eviction of Unauthorized Occupants Acts, those matters will get precedence. So instead of continuing with this on Thursday, I can keep it next week any day and we shall proceed thereafter.
Yes, yes.
It will be better because I'm not likely to forget within this short span. I'll remember it.
No, you Lordship will not forget, I know that.
Mr. Mehta can answer to it. If he wants to meet it in writing, he can take it. I am not passing any order for reply. I will consider it if Mr. Mehta deems it fit, if there is some factual dispute, so that we can have something of the sort on record. ঠিক আছে? হ্যাঁ? Same heading. ওখানে হেডিংটা বরঞ্চ ইয়ে করে দিন, it will appear on November 12 as a continuing matter. So that will help.
Yes.
Heading the continuing matter as heading because it is continuing. Thank you.
Sorry.